Good afternoon. The Constitutional Court has dismissed former President Jacob Zuma's application to have its earlier decision to sentence him to 15 months in jail for contempt of court rescinded. Zuma wanted the apex court to overturn its earlier judgment, arguing that his rights were violated as his incarceration did not follow a criminal case. The former president's contempt of court conviction and sentence stemmed from his defiance of the Constitutional Court order to continue appearing before the Commission of Inquiry into allegations of state capture. In its judgment, the court cited the finality in litigation matters for dismissing the application. It also says Zuma's application failed to meet the rescission requirement. The former president was also ordered to pay all the legal costs.
Mr. Zuma has met neither the requirements of a rescission in terms of Rule 42, subsection 1A, nor the requirements of one as governed by the common law. Mr. Zuma is seeking to reopen the merits of the contempt proceedings, which have been disposed of already. And it is contrary to interest of justice to recall that matter to life by expanding the grounds of rescission and reconsidering the judgment and order handed down on 29 June 2021. It is unfortunate, to say the very least, that Mr. Zuma failed to bring the submissions with which he now arms himself to the Constitutional Court before we reach this point. For all that can be said is that the predicament in which he now finds himself is not the making of the courts, nor does the solution lie with the courts. The hands of the Constitutional Court are bound, and Mr. Zuma himself bound them. It must, of course, be emphasized that rescission is an avenue of legal recourse, remains open, but only to those who advance meritorious and bona fide applications and who have not at every turn of the page sought to abuse judicial process.